So in the Abernathy versus Superior Woods case, we're looking at a videotape of a sawmill or a lumber yard operating, and the defendant lumber mill made this videotape. It says so that the jury would have a sense of what it looks like when logs are being unloaded. The plaintiff in this case had been injured at the lumber mill, and in this case the defendant wanted to show the jury, it says, just what things looked like when they were unloading the logs. The district court, however, said you cannot show this video with the audio recording on, and you had to turn the audio entirely off. And the reason was something very specific to the defense in this case. The lumberyard had claimed that that the victim should have heard the forklift turn loose of the logs and gotten out of the way. And the judge in this case says, the trial judge in this case, it said, you cannot show this video with the audio because the microphone wasn't placed where the plaintiff was standing when he was injured. And so it might give the jury an unrealistic expectation of the level of noise. And so therefore, we're going to exclude this evidence on the ground that it might give the jury a false impression. Now, of course, the plaintiff's lawyers would have been free to cross-examine, would have been free to say, wait a second, where was the microphone placed? Wait a minute, is this actually a real reflection of what the sound would have been like in the working lumberyard? But the trial court and then Judge Posner on appeal agrees that this could have distracted the jury from really appreciating what the level of noise would have been like, or more specifically, for thinking this is an accurate representation when there's nothing to compete with it. We can simply say, whatever it actually sounded like that day, this wasn't it. But that still left the jury with the sound in its head of what they thought it would have, or that's the only sound that they would have heard, suggesting that this was what the lumberyard sounded like. So in this case, Judge Posner says, look, this is not the only way the trial judge could have gone, but it certainly wasn't unreasonable for the trial judge to conclude that a video that has this level of sound that was produced by amateurs, not by a professional production company, that made no effort to accurately reflect the level of sound that the plaintiff would have heard, carries with it a real risk of prejudicing the jury, of making the jury think the sound was less than it was on that particular occasion. Now, there's something very worth noting here. When we go back to the text, and actually let's do that. Let's go back to the text of the of Rule 403, balancing prejudice and probative. When we go back to the text of 403, actually that's the video. When we go back to the text, what we see is that it looks like that all the cards are lined up in favor of admissibility. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one of the following forms of prejudice. It sounds like that standard is always going to lead to admissibility. Judge Posner in this case he actually very much applauds the trial judge for saying, look, it would have been fine to admit it, but I'm glad he excluded it in this case because there's a real sense in which a jury might have gotten a false impression. So when we read 403, we think that the deck is just stacked for admissibility, and under the language of the rule it is. But there's another layer that you have to consider when we're looking at any of these rules of evidence, particularly 403. And that is that when an appellate court reviews a trial judge's decision admitting or excluding a piece of evidence, it does so under the abuse of discretion standard, which means that regardless of what the rules say, the trial judge has a great deal of discretion in interpreting these rules, and therefore, or at least when that judge is being reviewed, the judge has a great deal. The judge is being given a great deal of deference. And so, as a practical matter on the ground, what that means is that trial judges have a great deal of power to interpret these rules, subject to a lighter-handed review in evidentiary cases than you might get in other cases, at least in theory. So this case stands for two propositions. One, that obviously, if as all three of the cases have done in this section, if the prejudicial value of the evidence substantially outweighs its probative value, the judge may, but usually that means must, exclude it. But also, even if the evidence is a little bit more equipoised than that, the standard by which appellate courts will review trial court decisions means that judges have more power than this rule would make you think, to kick out prejudicial evidence, even if it doesn't substantially outweigh the probative value. That the judge is rarely going to be reversed on a 403 issue. So those are a couple of takeaways. The standard says one thing, and it's not a bad starting place, but you have to then consider on the ground, what does it look like for a trial judge when the standard by which his decisions or her decisions under these rules are going to be reviewed, for only when there's an abuse of discretion will the judge be reversed. So there's more leeway in this 403 to exclude, as the Abernathy versus Superior Hardwoods demonstrates. There's more power that the trial judge has to exclude than the rule might initially make you think.